Question 1. Market definition and the SNP test. In a high-stakes environment where multiple challenges arise due to rapid industry consolidation, a company operating in the cloud computing sector seeks to acquire a competing firm. The Federal Trade Commission, FTC, initiates an investigation to assess whether the merger would substantially lessen competition in the relevant market. To determine market boundaries, the agency applies the small but significant and non-transitory increase in price test. However, a dispute arises over the proper product market definition. The acquiring company argues that cloud storage services should be considered part of a broader data management solutions market, while regulators contend that standalone cloud storage is a distinct market. Which of the following factors would most likely support the regulator's narrower definition? A. The presence of alternative data management solutions, such as on-premise servers, that could serve as substitutes for cloud storage. B. Evidence showing that 5% price increase in cloud storage services does not lead customers to switch to broader data management solutions. C. The existence of large enterprise customers who purchase bundled data services, including cloud storage and cybersecurity solutions. D. Finding that network effects in cloud computing lead to natural monopoly, making market definition irrelevant to antitrust analysis. Answer: B. Evidence showing that a 5% price increase in cloud storage services does not lead customers to switch to broader data management solutions. Explanation: the SNP test, commonly known as the hypothetical monopolist test, is used to define relevant product and geographic markets in antitrust cases. It asks whether a small but significant and non-transitory increase in price, typically 5.10%, would cause customers to switch to alternative products to make the price increase unprofitable. B is correct because if customers do not switch to broader data management solutions in response to price increase in cloud storage, this indicates that cloud storage is a distinct market rather than part of larger data management solutions market. A is incorrect because alternative data management solutions like on-premise servers might not be close substitutes if customers do not readily switch to them in response to price changes. C is incorrect because the existence of large enterprise customers purchasing bundled services does not necessarily mean cloud storage is part of broader market. Bundling does not determine substitutability. D is incorrect because network effects and monopoly considerations are separate from market definition and would not make the SNP test irrelevant. Relevant legal framework. The horizontal merger guidelines issued by the Dutch and FTC emphasize the importance of market definition and the SNP test in merger analysis. Courts have also relied on this test in cases such as FTC v. Staples, Inc. 1997 and United States v. HR Block, Inc. 2011 to assess market boundaries. Question 2. Exclusive dealing and tying arrangements. During the introduction of new methods where coordination between suppliers and distributors is critical, a dominant software company implements a licensing agreement requiring hardware manufacturers to pre-install its proprietary cybersecurity software as a condition of licensing its widely used operating system. Competitors argue that this practice constitutes an illegal arrangement under the Sherman Act. The software company defends its actions by claiming that the cybersecurity software enhances user experience and prevents malware attacks. Under which circumstances would this tying arrangement be deemed anti-competitive? A. If the licensing requirement substantially forecloses competing cybersecurity software providers from accessing the market. B. If customers willingly choose to bundle cybersecurity software and are not forced to use it. C. If the software company proves that integrating cybersecurity features significantly improves the overall performance of the operating system. D. If other operating systems also include built-in cybersecurity features, making the market competitive. Answer: A. If the licensing requirement substantially forecloses competing cybersecurity software providers from accessing the market. Explanation: a tying arrangement occurs when a seller conditions the sale of one product, the tying product, on the purchase of another product, the tied product. Under Section 1 of the Sherman Act and Section 3 of the Clayton Act, tying is illegal if it has anti-competitive effects. Courts evaluate tying claims using the per rule or the rule of reason, depending on the market impact. A is correct because a tying arrangement becomes anti-competitive if it forecloses a significant portion of the market to competing providers, reducing consumer choice and innovation. B is incorrect because the voluntary use of the software does not eliminate the anti-competitive effects of the tying arrangement if manufacturers are still required to bundle it. C is incorrect because efficiency benefits must be weighed against foreclosure effects. Pro-competitive justifications are relevant. They do not automatically make the practice lawful. D is incorrect because the presence of other operating systems does not negate the potential monopolistic impact of the tying arrangement if the dominant firm controls a significant market share. Relevant legal framework: the United States v. Microsoft Corp. 2001 cases. A key precedent where Microsoft was found to have engaged legal tying by bundling Internet Explorer with Windows. Courts have also examined tying in cases like Jefferson Parish Hospital District No. 2 v. Hyde 1984 and Eastman Kodak Company v. Image Technical Services Inc. 1992. Question 3. Collusion and price fixing. While analyzing the root causes of sequential problems in an industry characterized by limited competition, a group of pharmaceutical companies engaged in frequent information exchanges about future pricing strategies under the guise of market stabilization discussions. Following an investigation, the Dutch alleges that these discussions constitute price fixing under Section 1 of the Sherman Act. The company argue that their meetings are merely intended to prevent market volatility and ensure supply chain stability. Which of the following factors would most strongly indicate that the companies have engaged in illegal price fixing? A. The company's prices remain stable over time, even in the absence of explicit agreements. B. The companies frequently adjust prices independently in response to supply and demand conditions. C. Internal emails reveal discussions explicitly coordinating price increases across competing firms. D. The company's executives publicly deny any intent to engage in collusion. Answer: C. Internal emails reveal discussions explicitly coordinating price increases across competing firms. Explanation: price fixing is per violation of Section 1 of the Sherman Act, meaning that it is illegal regardless of its impact on the market. Collusion can occur through explicit agreements or tacit coordination, and courts often rely on direct and circumstantial evidence to establish liability. C is correct because direct evidence, such as internal communications showing explicit agreements to fix prices, is the strongest proof of illegal price fixing. A is incorrect because price stability alone does not prove collusion. It could be a natural market outcome. B is incorrect because independent pricing decisions based on market conditions indicate competition rather than collusion. D is incorrect because public denials do not outweigh substantive evidence of an agreement. Relevant legal framework: courts have consistently held that explicit agreements to fix prices are illegal per se. Is C. Cases like United States v. Socorro Vacuum Oil Company 1940 and United States v. Apple Inc. 2013. Even tacit collusion can be actionable under FTC v. Cement Institute 1948 if there is strong circumstantial evidence of coordination. Question 4. Market power and abuse of dominance. While investigating a complicated issue between different market participants, regulators uncover that a dominant e-commerce platform has allegedly been using its market power to disadvantage third-party sellers. The platform controls 75% of the online retail marketplace and has been accused of using seller data to develop competing private label products. Competitors are that this behavior constitutes an abuse of dominance, while the company defends itself by claiming that its actions promote innovation and consumer choice. Which of the following factors would most strongly indicate that the platform has violated antitrust law? A. The platform's private label products are competitively priced and offer better quality than third-party alternatives. B. Internal company documents show that third-party seller data was used to create private label products, which were then given preferential search rankings. C. The company's terms of service require sellers to adhere to certain quality standards before being listed on the platform. D. The company does not prevent third-party sellers from using other e-commerce platforms to sell their products. Answer: B. Internal company documents show that third-party seller data was used to create private label products, which were then given preferential search rankings. Explanation: under Section 2 of the Sherman Act, dominant firms are prohibited from engaging in exclusionary conduct that unfairly disadvantages competitors. The European Commission and U.S. regulators have scrutinized similar practices in the Amazon antitrust investigations where the company was accused of leveraging third-party seller data to compete unfairly. B is correct because using seller data to create competing products, then manipulating search rankings to favor those products is a form of self-preferencing, which can be anti-competitive. A is incorrect because offering competitive prices alone is not an antitrust violation unless it is coupled with exclusionary conduct. C is incorrect because requiring sellers to meet quality standards does not necessarily harm competition. D is incorrect because allowing sellers to use other platforms does not excuse exclusionary conduct within the dominant firm's ecosystem. Question 5. Horizontal restraints and price fixing. During a major transformation where existing methods of pricing are being challenged, several leading airlines form an industry association to discuss how to navigate fluctuating fuel costs. Internal communications reveal that executives have been sharing future pricing strategies and coordinating ticket prices to reduce market volatility. The Department of Justice Dutch launches an investigation suspecting collusion. Under what conditions would this conduct be deemed illegal price fixing? A. If the discussions resulted in explicit agreements among competitors to set or stabilize prices. B. If airlines experienced similar fuel cost increases and independently adjusted their prices. C. If consumers had alternative options, such as budget airlines, which were not part of the discussions. D. If the airlines claim they were only exchanging information to improve efficiency. Answer: A. If the discussions resulted in explicit agreements among competitors to set or stabilize prices. Explanation: price fixing is a violation of Section 1 of the Sherman Act, meaning it is automatically illegal regardless of intent or justifications. Courts evaluate collusion based on direct agreements between competitors to set prices, coordinated conduct that eliminates independent decision-making. In United States v. Saucony Vacuum Oil Company, 1940, the Supreme Court ruled that any agreement among competitors to stabilize prices is unlawful. A is correct because explicit agreements among competitors to control pricing are illegal. B is incorrect because independent responses to fuel cost changes are lawful if no collusion exists. C is incorrect because the presence of alternative airlines does not justify price fixing. D is incorrect because exchanging future pricing information can still be considered collusion. Question 6. Mergers and market concentration. When scaling up operations that experience significant market consolidation, a major pharmaceutical company announces plans to acquire one of its largest competitors. Regulators warn that the merger could significantly increase market concentration, leading to higher drug prices and fewer choices for consumers. The company argues that the merger will create efficiencies, lower production costs, result in more innovation. Under antitrust law, which of the following factors is most relevant in determining whether the merger should be approved? A. Whether the merger will substantially lessen competition or tend to create a monopoly. B. Whether the company has promised not to raise prices for at least 5 years post-merger. C. Whether the merger will make the company the largest pharmaceutical firm in the world. D. Whether the merger creates short-term cost savings regardless of competitive effects. Answer: A. Whether the merger will substantially lessen competition or tend to create a monopoly. Explanation: under Section 7 of the Clayton Act, mergers that substantially lessen competition or create a monopoly are prohibited. The Herfindahl-Hirschman Index is used to measure market concentration pre- and post-merger. A is correct because courts and regulators assess whether the merger will reduce competition in the market. B is incorrect because a temporary price freeze does not prevent long-term anti-competitive effects. C is incorrect because a firm's size alone is not illegal, but reduced competition is. D is incorrect because cost savings alone do not justify merger if it harms competition. Relevant case law: FTC v. Staples, 97, blocked merger based on market concentration concerns. Question 7. Noah Pennington doctrine and lobbying. During the introduction of new methods where coordination with government agencies is necessary, a group of energy companies lobbies Congress for stricter environmental regulations that would disproportionately harm smaller competitors. The Federal Trade Commission (FTC) investigates whether this conduct constitutes an antitrust violation. The companies claim they are simply petitioning the government. Policy changes. Under what conditions would this conduct be immune from antitrust liability? A. If the company's actions are genuinely aimed at influencing government policy rather than restraining trade. B. If the companies secretly meet to divide markets while lobbying Congress. C. If the companies use misinformation to mislead lawmakers and exclude competitors. D. If the companies coordinate to raise prices after the regulation is passed. Answer: A. If the company's actions are genuinely aimed at influencing government policy rather than restraining trade. Explanation. The Noah-Pennington Doctrine grants antitrust immunity to companies petitioning the government even if their actions reduce competition. However, sham mobbing intended solely to harm competitors is not protected. A is correct because genuine lobbying efforts to influence policy are protected. B is incorrect because secret market allocation is an antitrust violation. C is incorrect because misrepresentation to regulators may remove immunity. D is incorrect because price coordination post-lobbying could be an illegal agreement. Relevant case law: Eastern Railroad President's Conference v. No Motor Freight, Inc. 1961 upheld the petition but noted exceptions for sham activities. Question 8. Exclusive dealing and tying arrangements. When analyzing a complex market strategy that significantly changes industry practices, regulators discover that a software company requires customers who purchase its operating system to also buy its proprietary security software. A competitor in the security software market claims this arrangement is anti-competitive and violates antitrust laws. Under what conditions would this tying arrangement be deemed illegal? A. If the company has significant market power in the operating system market and the arrangement forecloses competition in the security software market. B. If customers are still able to buy competing security software separately from other sellers. C. If the company argues that bundling improves efficiency and provides better security for users. D. If customers do not complain about the practice and are satisfied with the bundled product. Answer A. If the company has significant market power in the operating system market and the arrangement forecloses competition in the security software market. Explanation. A tying arrangement occurs when a firm requires the purchase of one product. The tying product is a condition for obtaining another. The tied of product. Under Section 1 of the Sherman Act and Section 3 of the Clayton Act, tying is illegal if market power. The firm has significant power in the tying product market. Foreclosure of competition. The arrangement significantly limits competitors' access to the tied product market. Coercion. Consumers are forced to purchase the tied product. A is correct because if the firm controls the operating system market, this restricts competition in the security software market, making it illegal under cases like United States v. Microsoft Corp. 2001. B is incorrect because the ability to buy alternatives does not matter if competition is harmed. C is incorrect because efficiency claims do not override anti-competitive effects. D is incorrect because customer satisfaction does not negate antitrust violations. Question 9. Predatory pricing and monopolization. During the implementation of a major shift in pricing policies, a dominant retail chain reduces prices on essential goods below cost for an extended period. Competitors are unable to sustain similar losses and exit the market. After achieving dominance, the retail chain raises prices significantly. Which factor is most critical in proving this is illegal predatory pricing? A. Evidence that the company deliberately priced below cost with the intent to eliminate competition. B. The company's claim that low prices benefited consumers in the short term. C. The fact that consumers voluntarily switched to the retailer for better deals. D. The number of new competitors that entered the market after the pricing strategy was implemented. Answer A. Evidence that the company deliberately priced below cost with the intent to eliminate competition. Explanation. Predatory pricing occurs when a company deliberately sells below cost to drive competitors out and then raises prices once monopoly power is achieved. This is prohibited under Section 2 of the Sherman Act and clarified in Brooke Group Limited v. Brown and Williamson Tobacco Corp. 1993, which set the standard below pricing. The firm prices its goods below an appropriate measure of cost recoupment. The firm can raise prices later to recover its losses. A is correct because proving intent and recoupment is key to a predatory pricing claim. B is incorrect because short-term consumer benefits do not excuse monopolization. C is incorrect because consumer choice alone does not negate predatory conduct. D is incorrect because market entry does not always counteract harm from predatory pricing. Question 10. Vertical mergers and competitive harm. While assessing the implications of an industry-altering merger, regulators examine a deal between a major movie studio and a national movie theater chain. Independent theaters argue that the merger will lead to preferential treatment for the studio's films, making it harder for them to compete. Which factor is most relevant in determining whether the merger should be blocked? A. Whether the merger will significantly reduce competition by limiting access to top-grossing films. B. Whether consumers prefer the movies produced by the studio. C. Whether the studio is expanding its business operations legally. D. Whether ticket prices are lower immediately after the merger. Answer: 8. Whether the merger will significantly reduce competition by limiting access to top-grossing films. Explanation: vertical mergers, mergers between companies at different levels of the supply chain, can be illegal under Section 7 of the Clayton Act if they substantially lessen competition. The Dodge 2020 vertical merger guidelines emphasize foreclosure concerns if the merged company denies rivals access to essential inputs. If the merger strengthens firms' ability to harm competition. A is correct because if the merged company restricts independent theaters from accessing major films, it harms competition. B is incorrect because consumer preference does not determine legality. C is incorrect because legal business expansion is irrelevant to antitrust violations. D is incorrect because short-term price changes do not negate competitive harm. Question 11. Cartel behavior and bid rigging. During the introduction of stricter regulations, multiple construction firms coordinate their bids for a large government contract. Instead of competing, they agree on predetermined winners in exchange for subcontracting work. How would regulators prove this is illegal bid rigging? A. By demonstrating a pattern of coordinated bidding among competitors. B. By analyzing whether the winning bidder was higher than expected market rates. C. By assessing whether customers complained about the pricing. D. By determining if the firms benefited from the agreement. Answer: A. By demonstrating a pattern of coordinated bidding among competitors. Explanation: bid rigging is a per violation of Section 1 of the Sherman Act and occurs when competitors manipulate competitive bidding to eliminate fair market pricing. Identifying collusion, authorities look for rotating winners, complementary bids, and cover pricing. Market impact: if the scheme artificially inflates costs, it harms competition. A is correct because a pattern of coordination proves collusion. B is incorrect because bid rigging is illegal regardless of price levels. C is incorrect because antitrust violations do not require consumer complaints. D is incorrect because financial gain does not justify anti-competitive agreements. Question 12. Mergers and market definition. During a major transformation where existing methods of market assessment are being revised, regulators must determine whether a proposed merger between two telecommunications firms will substantially lessen competition. The merging companies argue that their services compete in a broad market that includes satellite and broadband providers, while regulators contend that the relevant market is much consisting only of fiber optic broadband providers. How should regulators define the market to assess the competitive impact of the merger? A. Define the market broadly to include all internet service providers, as they all provide connectivity. B. Narrowly define the market to include only fiber optic broadband providers if consumers do not consider other options close substitutes. C. Exclude satellite and broadband providers from the market definition since they operate under different regulatory requirements. D. Use a hybrid definition that weighs both the merging company and regulators' perspectives equally. Answer: B. Narrowly define the market to include only fiber optic broadband providers if consumers do not consider other options close substitutes. Explanation: the market definition in antitrust law determines the scope of competition and whether a merger could lead to anti-competitive effects. Under the SNIP test, small but significant and non-transitory increase in price, regulators assess whether consumers would switch to alternatives in response to a price increase. If fiber optic broadband is distinct from satellite and DSL due to factors like speed, reliability, and switching costs, a narrow market definition is appropriate. This follows the DIGI and FTC merger guidelines, which require identifying product and geographic markets to evaluate competitive harm. Courts have upheld similar analyses in cases like United States v. AT&T 2011 and FTC v. Staples, Inc. 1997. Question 13. Price fixing and rule of reason. While examining inconsistencies across various units of a national grocery chain, investigators uncover a pattern of price coordination among competing suppliers of perishable goods. The suppliers claim their conduct is justified because uniform pricing ensures stability in the market and reduces supply chain disruptions. Under what circumstances would this agreement be considered a violation of antitrust laws? A. If the agreement directly sets prices among competitors, it is automatically illegal under the per rule. B. If the agreement is justified by economic efficiencies, it will always be upheld under the rule of reason. C. If the suppliers are in separate geographic markets, price coordination is lawful. D. If the prices were set by an industry association rather than individual firms, it does not constitute illegal collusion. Answer A. If the agreement directly sets prices among competitors, it is automatically illegal under the parole. Explanation. Price fixing is a illegal restraint of trade under Section 1 of the Sherman Act, 1890. Unlike practices evaluated under the rule of reason, price fixing does not require proof of market harm. Agreements between competitors to set prices are inherently illegal. The Supreme Court has ruled in United v. Socony Vacuum Oil Company, 1940, that any agreement among competitors to manipulate prices is unlawful regardless of justification. Arizona v. Maricopa County Medical Society, 1982, reinforced that even if price agreements lead to cost savings or predictability, they remain illegal. Question 14. Tying arrangements in technology markets. In a high-stakes environment where multiple challenges arise in enforcing fair competition in digital markets, a major software company requires customers who purchase its cloud computing service to also subscribe to its cybersecurity package. Competitors argue that this constitutes an illegal tying arrangement. Under what conditions would this practice be deemed unlawful? A. If the company lacks market power in either cloud computing or cybersecurity, the tying arrangement is legal. B. If customers have alternative options in the cybersecurity market, the tie is legal regardless of market power. C. If the company has substantial market power and the tie forecloses competition, it may be illegal. D. If the cybersecurity package is offered at a discounted price with the cloud service, it is not considered arrangement. Answer. C. If the company has substantial market power and the tie forecloses competition, it may be illegal. Explanation. Tying arrangements occur when a firm with market power in one product forces customers to purchase a second product, potentially foreclosing competition. Section 3 of the Clayton Act and Section 1 of the Sherman Act prohibit anti-competitive tying. If the firm has market power in the tying product, there are two distinct customers have no viable alternative, and the arrangement harms competition. In United States v. Microsoft Corp. 2001, the company's bundling of Internet Explorer with Windows was challenged as an unlawful tie because it restricted competitors' access to the browser market. If the cloud service firm has market power and its cybersecurity package limits competition, regulators may find it illegal. Question 15. Predatory pricing and monopolization. While analyzing the root causes of sequential problems in the airline industry, regulators suspect that a dominant airline has been pricing its tickets below cost on certain routes where a smaller competitor operates only to raise prices once the competitor exits. What must regulators prove to establish illegal predatory pricing? A. The dominant airline is selling below cost with the intent and ability to eliminate competitors and recoup losses. B. The airline's pricing strategy is aggressive but does not explicitly aim to drive out competitors. C. As long as customers benefit from lower prices, predatory pricing cannot be illegal. D. Any below-cost pricing is automatically considered an antitrust violation. Answer A. The dominant airline is selling below cost with the intent and ability to eliminate competitors and recoup losses. Explanation. Under Section 2 of the Sherman Act, predatory pricing occurs when a firm deliberately prices below cost to eliminate competitors and later raises prices to recoup losses. The Supreme Court in Brooke Group Limited v. Brown and Williamson Tobacco Corp. 1993 said a two-part test. Pricing must be an appropriate measure of cost, e.g., marginal or average variable cost. There must be a dangerous probability of recouping losses through higher prices post-exit. If the airline lacks the ability to sustain losses and later monopolize the market, predatory pricing is unlikely. However, in cases like American Airlines, 2003 airlines have been found liable when engaging in below-cost pricing on targeted routes to eliminate rivals. Question 16. Exclusive dealing agreements and competitive harm. When implementing new protocols in a shared environment, regulators review an exclusive supply agreement between a dominant beverage manufacturer and nationwide retailers, which prevents them from selling competing brands. Competitors argue that this arrangement forecloses market access. Under what conditions could this exclusive dealing agreement violate antitrust laws? A. If it substantially forecloses competition and lacks pro-competitive justifications. B. If exclusivity benefits the manufacturer, the agreement is legal regardless of competitive harm. C. Exclusive agreements are always illegal under the Sherman Act. D. Competitors must prove they suffered actual economic losses for enforcement action. Answer A. If it substantially forecloses competition and lacks pro-competitive justifications. Explanation. Exclusive dealing agreements can be illegal under Section 3 of the Clayton Act and Section 1 of the Sherman Act if they substantially foreclose market access and harm competition. The FTC v. Brown Shoe Company, 1962, case established that exclusivity is illegal if it significantly limits rivals' ability to compete. However, rule of reason applies, meaning courts consider pro-competitive benefits, such as improved supply chain efficiency. If the manufacturer controls large market share, exclusive agreements can create barriers to entry, making them unlawful. Question 17. Market power and vertical integration. As part of a long-term initiative to assess competitive risks in the retail sector, regulators are investigating whether a dominant online marketplace's acquisition of major logistics provider could harm competition. The company argues that vertical integration will reduce costs and improve efficiency, while competitors claim it will give the marketplace an unfair advantage. Under what conditions would regulators view this acquisition as an antitrust violation? A. If the acquisition allows the company to deny logistics services to competing retailers and foreclose competition. B. If the marketplace benefits from lower costs, the acquisition is always legal. C. Vertical integration is inherently pro-competitive and does not raise antitrust concerns. D. The government must prove the acquisition eliminates all competitors before blocking it. Answer A. If the acquisition allows the company to deny logistics services to competing retailers and foreclose competition. Explanation. Vertical integration, where company expands into different stage of the supply chain, can be pro-competitive if it leads to efficiencies. However, under Section 7 of the Clayton Act, regulators may block or challenge mergers if they substantially lessen competition or lead to foreclosure of rivals. Key foreclosure where the acquiring firm denies access to critical input logistics services to competitors. In United States v. AT&T 2018, the government challenged AT&T's acquisition of Time Warner, arguing it could use its control of content to disadvantage competitors. If the online marketplace can raise rivals' costs or discriminate against competitors, regulators may intervene. Question 18. Resale price maintenance and manufacturer control. During efforts to reassess long-standing distribution agreements, regulators examine a manufacturer's policy requiring retailers to sell its luxury watches at fixed minimum price. Group of retailers challenges this policy, arguing it restricts price competition. Under what legal framework would courts evaluate the manufacturer's pricing policy? 8. Under the rule of reason, courts will analyze whether the policy has pro-competitive justifications. B. The policy is automatically illegal under per rules. C. Manufacturers cannot set minimum resale prices under any circumstances. D. As long as the manufacturer does not have monopoly, the policy is legal. Answer A. Under the rule of reason, courts will analyze whether the policy has pro-competitive justifications. Explanation. Resale price maintenance, RPM, occurs when a manufacturer sets minimum prices for retailers. Historically, RPM was considered illegal under Optimiles Medical Company v. John D. Park and Sons Company, 1911. However, in League and Creative Leather Products Inc., Vorpis SKS Inc., 2007, the Supreme Court ruled that RPM agreements should be evaluated under the rule of reason, meaning courts must consider pro-competitive benefits, e.g., preventing price wars that could devalue the brand, anti-competitive harm, e.g., restricting price competition among retailers. If RPM stifles competition and harms consumers, it may violate Section 1 of the Sherman Act. However, when used to maintain brand image, courts may uphold it. Question 19. Monopolization and essential facilities. While navigating a highly concentrated digital marketplace, a group of independent software developers accuses a dominant operating system provider of restricting access to its app store, making it difficult for competitors to distribute their products. Under what circumstances could this practice constitute unlawful monopolization? A. If the App Store is deemed an essential facility and denial of access harms competition. B. If the operating system company has market power, any restriction it imposes is illegal. C. As long as developers can distribute software through other channels, the practice is legal. D. Monopolization claims require proof that all competition is eliminated. Answer A. If the App Store is deemed an essential facility and denial of access harms competition. Explanation: monopolization under Section 2 of the Sherman Act requires market power. The firm must have significant control over the relevant market. Exclusionary conduct: the firm must engage in anti-competitive behavior. The essential facilities doctrine applies when a dominant firm controls an infrastructure necessary for competition and denies it to rivals without justification. Courts have recognized essential facilities in cases like Ottertail Power Company v. United States, 1973, where a power company was required to provide access to transmission lines. If the App Store is the only viable means of distribution and access is unfairly restricted, it could violate antitrust laws. However, if alternative distribution channels exist, courts may not intervene. Question 20. Collusion and algorithmic pricing. During an advanced study of digital competition, investigators discover that competing ride-sharing platforms use pricing algorithms that result in nearly identical fare structures. There is no direct agreement among the companies, but their algorithms adjust prices based on shared market data. Could this be considered collusion under antitrust law? A. Yes, if the algorithms facilitate tacit collusion that results in price coordination. B. No, because explicit communication is required for an antitrust violation. C. Only if a regulator can prove the companies manually adjusted their prices. D. Algorithmic pricing is exempt from antitrust laws. Answer A. Yes, if the algorithms facilitate tacit collusion that results in price coordination. Explanation: collusion does not always require explicit agreements. Under Section 1 of the Sherman Act, firms engaging in tacit collusion, where competitors reach the same outcome without direct communication, can still violate antitrust laws. In United States v. Apple Inc., 2013, Apple was found guilty of coordinating e-book prices through an algorithmic pricing model, even though the agreements were indirect. The European Commission has also investigated algorithmic collusion, warning that AI-based pricing tools could lead to market manipulation without direct human involvement. If companies design pricing algorithms to align their behavior and reduce competition, they risk violating Question 21. Antitrust in labor markets and no-poach agreements. When identifying patterns in employment practices across the tech industry, regulators find that several major firms have agreed not to recruit each other's employees. The companies claim this arrangement reduces turnover and promotes stability. Under what conditions would this agreement be considered an antitrust violation? A. If the agreement limits worker mobility and suppresses wages, it is per illegal. B. If the firms are not direct competitors in the product market, the agreement is legal. C. No-poach agreements are only illegal if they involve wage fixing. D. Companies are free to make agreements about hiring as long as they are informal. Answer A. If the agreement limits worker mobility and suppresses wages, it is per illegal. Explanation: no-poach agreements violate Section 1 of the Sherman Act when they restrict worker mobility and reduce wages. In United States v. Adobe Systems Inc., 2010, the Dutch sued Apple, Google, Intel, and other tech firms for anti-competitive hiring agreements, arguing they suppressed salaries and violated labor market competition principles. Did an FTC have declared naked no-poach agreements as per illegal, meaning they do not require proof of harm? Simply the existence of the agreement is enough for violation. Courts apply the rule of reason if the agreement has legitimate business justifications, e.g., joint ventures. Question 22. Conflict between formal requirements and practical constraints. In a situation where formal requirements conflict with practical implementation, an organization must decide how to prioritize its compliance obligations while maintaining operational efficiency. The financial services firm is subject to new regulations that require additional reporting, but implementing the system increases processing times, affecting customer experience. What is the best approach to resolve this conflict? A. Prioritize regulatory compliance even if it reduces customer satisfaction. B. Seek a compliance waiver to delay implementation. C. Implement a phased approach allowing gradual integration while improving processing efficiency. D. Reduce the scope of reporting to maintain current service levels. Answer: C. Implement a phased approach, allowing gradual integration while improving processing efficiency. Explanation: regulatory compliance is non-negotiable, but firms must also ensure operational effectiveness. A phased approach allows for compliance while improving system performance over time. Many organizations follow agile compliance strategies where incremental changes reduce disruption. Regulators often accept transition plans. Firms demonstrate good faith efforts. Question 23. Coordination in multi-department environments. In a large organization where multiple departments need to coordinate, a new enterprise software system is being introduced. However, resistance emerges because different departments have conflicting workflows. How should leadership address this situation to ensure a smooth transition? A. Enforce immediate adoption and require all departments to adjust their processes. B. Allow each department to customize the system to fit their needs, even if integration is compromised. C. Facilitate cross-department workshops to align workflows and find common ground. D. Delay the transition until all departments fully agree on changes. Answer. C. Facilitate cross-department workshops to align workflows and find common ground. Explanation. Large organizations often struggle with departmental silos where different teams resist changes that disrupt existing workflows. Workshops and interdepartmental collaboration ensure that the system addresses common needs while maintaining integration. Change management strategies, including training and phased implementation, reduce resistance. Question 24. Managing unexpected outcomes in process improvement. When improving a process that shows unexpected results, a company finds that automation has reduced errors but also introduced new inefficiencies. While initial expectations were positive, the change led to bottlenecks in other areas. What is the best way to address this issue? A. Roll back the automation to restore previous efficiency. B. Conduct a root cause analysis to identify the underlying issues and adjust accordingly. C. Continue with the new process and let teams adapt over time. D. Increase manual oversight to compensate for inefficiencies. Answer. B. Conduct a root cause analysis to identify the underlying issues and adjust accordingly. Explanation. Automation often shifts inefficiencies rather than eliminating them. A root cause analysis helps determine whether the bottlenecks result from system limitations, data flow issues, or workflow mismatches. Lean process improvement techniques can optimize the system without fully reversing automation efforts. Question 25. Ensuring consistency across multi-location operations. In a multi-location scenario where consistency requirements are high, a retail chain is struggling with different regional branches implementing customer service policies in varying ways. This inconsistency leads to customer complaints. What is the best way to standardize operations without disrupting local flexibility? A. Enforce strict policies and require all branches to follow identical procedures. B. Develop a central framework with regional adaptability. C. Allow branches full autonomy and focus only on resolving complaints. D. Conduct periodic audits but avoid mandating changes. Answer. B. Develop a central framework with regional adaptability. Explanation. Standardization is essential for brand consistency, but regions may have unique customer expectations. A centralized framework with regional flexibility allows adaptation while ensuring compliance with core service principles. This is a common approach in franchise management and international retail operations. Question 26. Managing complex system failures. When dealing with a complex system that shows occasional failures, a hospital's new electronic medical records (EMR) system experiences intermittent disruptions affecting patient care. Some departments consider switching back to paper-based records. How should leadership respond? A. Identify the root cause of failures and implement targeted fixes. B. Revert to the old system until stability improves. C. Require staff to use both systems simultaneously to ensure redundancy. D. Accept temporary disruptions as part of the transition process. Answer. A. Identify the root cause of failures and implement targeted fixes. Explanation. Healthcare systems require high reliability, and intermittent failures indicate system weaknesses. Instead of reverting, leadership should diagnose failure points, whether related to infrastructure, software bugs, or user training gaps. Gradual improvements ensure long-term stability. Question 27. Coordinating emergency responses across departments. During an emergency response where multiple areas are impacted, a manufacturing company experiences a cybersecurity breach that affects both production and customer data. The team focuses on containment while legal and teams handle communication. How should leadership coordinate the response? A. Assign a single team to manage the entire situation. B. Establish A crisis coordination unit to align efforts across all departments. C. Prioritize its efforts and address public relations afterward. D. Minimize public communication to avoid liability risks. Answer. B. Establish a crisis coordination unit to align efforts across all departments. Explanation. Cybersecurity incidents require cross-functional coordination. A crisis coordination unit ensures that the legal and teams work in sync. Delayed public communication can worsen reputational damage, and failure to involve legal teams can lead to regulatory penalties. Question 20. Handling resistance during process overhaul. During a major transformation where existing methods must be replaced, a logistics company introduces AI-driven demand forecasting. However, long-time employees resist the change, fearing job displacement. How should management handle this situation? A. Provide training and demonstrate how AI complements their roles. B. Replace resistant employees with new hires who are more tech-savvy. C. Implement AI gradually without informing employees of long-term plans. D. Force immediate adoption, making resistance a performance issue. Answer. A. Provide training and demonstrate how AI complements their roles. Explanation. Workforce resistance is common in technology adoption. Successful change management involves upskilling employees rather than replacing them. Demonstrating AI role as support tool rather than a replacement can reduce fears and encourage adoption. Question 29. Managing hybrid approaches in time-sensitive environments. While managing a hybrid approach where timing issues impact performance, a financial firm must balance automated and manual risk assessments. While automation improves speed, manual reviews catch nuanced risks. How should the firm optimize its process? A. Rely solely on automation for efficiency. B. Maintain manual reviews for all cases to ensure accuracy. C. Use automation for routine cases and reserve manual reviews for high-risk scenarios. D. Alternate between manual and automated processes randomly. Answer. C. Use automation for routine cases and reserve manual reviews for high-risk scenarios. Explanation. A hybrid risk management strategy allows firms to leverage automation for efficiency while maintaining human oversight where needed. High-risk transactions often require contextual judgment, which algorithms struggle to handle alone. Question 30. Scaling up operations with resource constraints. When scaling up operations that experience significant bottlenecks, a software company expanding globally finds its cloud infrastructure struggling with demand surges. What is the best approach to ensure scalability? A. Preemptively build excess infrastructure capacity. B. Implement a cloud elasticity model to scale resources dynamically. C. Limit new user onboarding until infrastructure is upgraded. D. Accept performance degradation as a temporary issue. Answer. B. Implement a cloud elasticity model to scale resources dynamically. S. Explanation. Cloud elasticity allows systems to scale up and down automatically based on demand. This approach prevents excess costs while ensuring high availability. Many SaaS companies use auto-scaling to handle rapid growth without infrastructure over-provisioning.